I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, family? Welcome back to Sovereign Citizens Hall of Fame with your man TP. You guys asked for it, and today we are giving it to you. Another compilation dedicated to one judge. This is number 72, and we are dedicating this compilation to Judge Michael Olsaver out of the state of Michigan. Now, unfortunately, we haven't been able to cover a lot of Judge Olsaver's proceedings in his courtroom, but we were able to cover two different sovereign citizens that we're going to be sharing today. One of them has multiple appearances. The other one also has multiple appearances, but they just were too lengthy to add to this compilation. So we will put a link down in the description if you want to see Mr. Donald Lester's all 4 or 5 of his proceedings. With that being said, guys, there will be no commentary at the end of this video. Chapters will be added for your convenience. Thank you as always for joining us. Don't forget to like, share, comment, subscribe. You guys are loving the compilations, and I love giving them to you. So listen, let's go ahead and jump into number 72.
Okay, we are on the record in file 21-20513-FH, People versus Robert Joseph Matson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Mattson is present from the Lenawee County Jail. Mr. Mattson, my court notes indicated that at the last hearing, you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney, and if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Mattson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before, and your sovereign citizen arguments, I've rejected them all. Sir, do not interrupt me. Do you want to have a hearing or do you want to plead to
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within the 90 days to a trial or sooner.
All right. So Sierra will need about a 1-hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well, please.
Judge, is tomorrow too soon?
That is probably going to be too soon, yes.
You could do 3:30 on Monday, April 8th.
Maybe actually the subpoena, no, the prosecutor's office does.
Do we have anything else open that week? I hate to do it on a Monday because I never am certain that that's actually going to end at 3:30.
You have a jury trial the rest of that week. It looks like Wednesday. You have a prelim and a juvenile case at 2:30. I'm not sure how long that will last.
What is the jury trial?
The jury trial is Tory Marshall. You could do an 8 a.m. on Friday the 12th, and I can move the couple of sentencings.
No, let's do it on Monday then. We'll do it on Monday, May 8th. April 8th, I'm sorry. Monday, April 8th at 3:30. Mr. Mattson, do you want to be present in person for that hearing, or do you want to do it by Zoom?
It doesn't matter. Judge, whichever is best for the court should be fine with me.
All right, I think it will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day?
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names. But any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there. I don't see where any of it's going to affect the courts in any way, shape, or form.
All right, so the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not
it's not about the arrest. It's about the arrest for the violation of probation as well.
All right, the only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or
so
I've seen you just the other day, last week.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was
Yes,
Judge
I did.
Michael, and then there was you. I've seen both of you.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on
Well, hold
Monday.
up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Mattson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Mattson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation. As a result of that, your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation, so the court will conduct.
Let me speak to.
I've muted Mr. Mattson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Mattson. This hearing is concluded. People of the State of Michigan versus Donald Raymond Lester. We are here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for prosecutor of record Isaac Steen.
Samaris Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting at the almost. I'm saying that we can't see you, Mr. Lester. So Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter in order for us to move to trial. And he was very upset. I would add, just for the record, for his for appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing. And I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction,
I can't hear you. Can you speak up, please?
to the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not, and I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes, he was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared for trial.
I would also like to intervene here real quick, but that being said, the motion is just not for the jurisdiction, it's also for personal jurisdiction and subject matter jurisdiction. I had the right to a resisting unlawful arrest, and it's not being addressed. The Supreme Court ruling on that, I just read that not too long ago, and they arrested me for an old traffic ticket, is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules that after 10 years, under a lower felony, after 10 years, it's automatically expunged. So I'm trying to figure out how am I being charged with a habitual criminal. And also, I would like to get that in writing, that you said that you have jurisdiction over this case, but not the said person. And that's all in the motions that I sent over to the clerk's office. I also have them all notarized. I also have copies of everything that I sent over there. So there should be somewhere in y'all file that y'all should have it.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They're trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years, and then 2 R&Os, which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about the plea agreement that would allow him to be released today. So he is correct in that I did inform him of that, but it's not because of a habitual offender notice. And he asked me about that yesterday, and I reiterated again yesterday that that is not why. That was not why he's facing that amount of time. It was simply me held in worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again, deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so
Okay. So
Yeah,
whenever you get done, I'd like to address the issue too, please.
all right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or to the court by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go, can I address
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes, it would be.
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
Yeah, I mean, we'll just take a second. It's an added count for possession of meth in a park, which is a 2-year offense. And we were offering credit for time served, which is approximately 10 months. And we have no objection to a PR bond at the time the plea is taken.
Ms. McClure, could I just add that Mr. Sneed did inform me that you had authority to do fines and cost only on this as well?
No.
That be accurate?
I think that would be part of the credit for time served.
Thank you.
So the prosecution has made an offer to resolve the case if Mr. Lester were willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served and or fines and costs and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
How is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady since March. And when I did, she came in there and coerce me into trying to keep on my case.
All right, so Mr. Lester, that wasn't really responsive to the question that was asked. The question you're being
I
asked
don't know
right
nothing
now.
about that. I told her what it was then, and
Mr. Lester,
you keep trying to cut me off.
well, that's because you won't let me create the record and do my job. So I'm
trying to do my job. You're not the one sitting in jail, sir.
All right, so Miss
Your Honor, will you
All right,
please
so
mute
the-
my client? I don't want him to.
record
find
should
himself in
reflect that. The record should reflect that Mr. Lester had, I'm sorry, so. Mr. Lester, the question I'm asking and that I need an answer to is you've heard the offer that I've indicated the prosecution has made to you to resolve the case. Do you or do you not want to?
No, I'm not, because they had no business arresting me, Your Honor. And I wasn't bothering anybody.
A simple no is fine. That's all I needed. All I needed was no.
Quit talking to me like I'm a kid.
The answer is no, so we will proceed to trial next week. I don't think there's anything else we need to address this morning. So Mr. Lester,
I need a bond.
That you are done with court.
See what I'm saying?
All right. Ms. Hengen, are you ready to proceed?
Yes.
Mr. Mattson, don't interrupt me, please.
Right,
Mr. Mattson, do not interrupt me, please.
I think the court is making a big mistake here.
Mr. Mattson?
I've never signed anything for
Mr.
the court.
Mattson, if you don't stop talking, I'm going to your device.
Well, I didn't want
Mr.
Mr.
Mattson,
Daly
stop
as my
talking.
attorney. I'm a living flesh and blood man. They're trying to sentence an all caps name. It's not me. I'm a living flesh and blood man. You're after a fictional person. The only one I've ever taken an oath to is God Almighty Himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize.
And sir, you are Robert Joseph Mattson, correct?
So I'm a living flesh and blood man, attorney for a public officer or statutory citizen judge. I'm a living flesh and blood man.
All right. You are the living flesh and blood man who's known as Robert Matson, correct?
Attorney for Robert Joseph Mattson, which would be the all caps name. Judge, there was something that I was trying to talk to my attorney about. Before you let me out of the hospital, I was in the hospital or the jail. I was experiencing a lot of pain and trouble. The jail was not treating me properly. After I got out of the jail, I went to the hospital, and they hurried and rushed me to Toledo Hospital, where I almost died. Had I not been released from jail when I did, I would be dead in that county jail.
All right, Mr. Mattson, we're here for your sentencing hearing today. I'm not really able to address issues of medical treatment while at the jail.
Well, I was just saying that there was something I agreed
to.
Yes.
Mr. Mattson, don't interrupt me, please. The medical treatment that people receive at the jail is not within my purview, and I'm not going to address that today. So,
well, I was just saying I was going to address my
Mr. Mattson, do not interrupt me, please. Have you had an opportunity to read and review your pre-sentence report?
I did with the secretary for Mr. Daly.
Have you had an opportunity to discuss your pre-sentence report with Mr. Daly?
I haven't had an opportunity to discuss it with him. I did with the secretary.
My secretary got a hold of him.
Mr. Daly, if you could just let me allow him to finish his answer. What were you saying, Mr. Mattson?
I did with the secretary. I talked to her over the phone and told her everything looked good. And I believe Mr. Daly was supposed to get back a hold of me. I don't know if he got too busy or something else happened.
All right. Thank you, Mr. Mattson. Mr. Daly, you wanted to say something on that issue.
Yes, my secretary contacted him in regards to the PSI. He said everything was right. He had no complaints about anything. I still tried to contact him back, didn't get an answer.
All right. So what we'll do is if Mr. Daly, if you'd be willing to step out into the hallway, we have an iPad out there that we can log into the Zoom session.
But I don't think he needs that. He's ready to be sentenced, Your Honor. You have any other questions, Mr. Mattson?
Yeah, Judge, I think your court is making a big mistake here. I've not.
I appreciate that, Mr. Mattson, and we've
I'm not
discussed
doing
it
any of
before.
my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the
Mr. Mattson,
jurisdiction. I've never signed anything for
Mr.
the court.
Mattson, if you don't
in the
stop talking, I'm
contract.
going to mute your device. Okay? I've discussed all of these issues with you before.
Okay.
And
Well, I object, but I mean,
Mr.
you're going to
Mattson,
sentence me. That's what you're
all
doing.
right. I've muted Mr. Mattson's device because he won't stop interrupting me. Mr. Mattson, what I'm trying to tell you is that we have discussed these issues before. You've raised those issues. I've ruled against those issues. And ultimately, you pled guilty of your own choice to the controlled substance possession of narcotic less than 25 grams. And so I'm going to sentence you on that charge today. If you'd like, I will have Mr. Daly step into the hall and you can have a breakout session with him so you can speak with him about your pre-sentence investigation report. If you have questions or things that you want to talk with him about regarding that report. So I'm going to unmute your device now and I want you to tell me whether you want a breakout session with Mr. Daly or not.
Hello?
Yes, we can hear you now. You want a breakout session with Mr. Daly?
Well, I've tried to talk to Mr. Daly before, I mean,
Mr.
about this.
Mattson,
And,
answer my question. Do you
Yes,
want
sir.
a breakout session with Mr. Daly or not?
Your Honor, you're going to do what you're going to do. I mean, I've tried to talk to the courts and reason with the courts. I mean, if you're going to sentence me today, then I just file for an appeal. I'm an objection to anything that happens today. I was under duress when I took the plea due to my life was at stake.
Mr. Mattson, please answer my question. Do you want a breakout session with Mr. Daly or not?
Mr. Daly hasn't been much of help for me, Your Honor. So I mean,
That is not an answer to my question, Mr. Mattson. Please answer the question. Do you want a breakout session with him or not?
Sorry, Your Honor. It just ain't been doing me any help, no justice at all. I mean, I've already said what I had to say. If the courts is going to sentence me today, then that's what they're going to do. I don't agree with anything that's going on today. I'm sorry. It's just my life was at stake when I had talked to the courts.
All right, Mr. Mattson, please stop
Yes, sir.
talking. So you refuse to answer my question about whether you want a breakout session with Mr. Daly or not. The law.
Well, I didn't want
Mr.
Mr.
Mattson,
Daly
stop
as my
talking.
attorney. Yes, sir.
The record, I placed Mr. Mattson on mute again because he's continually interrupting me. Mr. Mattson, what I'm trying to explain to you is that you have the right to discuss your pre-sentence report with your attorney before the sentencing. I've asked you 4, 5, maybe 6 times now whether you want to have the opportunity for that breakout session, and you won't give me a simple yes or no answer. So what I'm going to do right now is ask Mr. Daly to step into the hallway. We'll set up that iPad. I'm going to put you in a breakout session with Mr. Daly in order to make sure that I comply with with your rights to have that breakout session. So at this point, I'm going to set that up, whether you want it or not, so that we have complied with that requirement.
Judge, I just had a repeat of a conversation earlier.
All right, Mr. Mattson, you're arguing the basis of your conviction. Again, you pled guilty to this charge. What I'm asking you is whether, Mr. Mattson, what I'm asking you is whether you'd wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report. So is any of that information inaccurate?
Inaccurate as far as the person that reports they're trying to sentence in all caps names. It's not me. I'm a living flesh and blood man. You're after a fictional person.
All right. So with respect to that argument, what the court will say is that I will leave the information that is in the pre-sentence report and deny what seems to be some kind of a request to modify the pre-sentence report based on an argument that doesn't state any cognizable legal theory about a difference between Mr. Mattson as a human being and Mr. Mattson as something else. So the pre-sentence report will stand.
Well, Your Honor, you never even explained to me what the jurisdiction was. I tried from the beginning to
Mr.
see what the
Mattson, all
jurisdiction
right.
of the court is.
I'm going to mute Mr. Mattson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is, it's not a legal argument at all. It is some kind of fanciful belief that there's a difference between Mr. Mattson, the human being, and Mr. Mattson as some other entity, which is not recognized by the law, and I'm not going to entertain it any further. The probation officers calculated the minimum sentencing guidelines in this case to be from 0 to 9 months. Do you agree with that computation of guidelines, Mr. David? I do. Thank you. Before the court passes sentence, Mr. Daly, is there anything you'd like to say on behalf of Mr. Mattson?
I've had the same conversations with Mr. Mattson the court's had. He's never wanted to talk about this case. He's always wanted to talk about what he perceived are constitutional issues. He pled guilty. He knew what he was doing. I do know that. I'm prepared to complete the sentencing now.
All right, Mr. Mattson, in a moment, I'm going to unmute your microphone and I'm going to give you an opportunity for allocution. That's an opportunity to say anything that you'd like to say on your own behalf before the court passes sentence.
Yes, sir. Can you hear me?
Is there anything you'd like to say on your own behalf?
You said that. I can say anything that I wish before sentencing.
You can.
I'm sorry, sir.
You can.
Okay. Yeah, yes, sir. Your Honor. I mean, before I took that plea, I told Mr. Daly that I wanted to sit there. I wanted him to sit there, get the cameras for the courts to prove that I was at the court date the day that I was put in jail, and said that that I wasn't in the court for a contempt of court. He said, and I told him I wanted to fight my case, but I had to be out because I had medical issues. Mr. Daly said that's fine and all, but if you stay here and you fight this case, they'll keep you in here for a year fighting your case. You will not be let out of jail. Your Honor, I couldn't do that. I was in major pain. I would have died in that jail. My proof is within the doctor's records in the hospital. I had a serious condition which would have left me dead within a week from the time that I took the plea. The following day after I got up, my wife was killed in a car accident. Because everything's been going downhill for me ever since. And now this with the courts. I don't feel that I've had a fair chance with the courts ever since I even started with the court, because the courts has not proven jurisdiction to me. I've not written any papers out agreeing in the contract saying that the courts can have any kind of jurisdiction over me. I have not relinquished any sovereign immunities that I have. I just don't feel that there's been anything fair, which is not going to be with the court system. I mean, I've tried to say I'm not a statutory person who is within your jurisdiction. If anything, I'd be considered constitutional, but I'm not even under the constitutional laws, but I will use them if I feel necessary as a constitutional living flesh and blood man. There is no injured party. The only injured party would be the state's laws, which the state cannot be the prosecutor, the injured party, and the judge. Nothing's right. The court case either had been dismissed or moved to a higher court. And I wasn't going to sit there and be left in jail to fight my case for a year. I would have been dead. I'd have been stupid not to sit there and just agree with a plea that I didn't even agree with in the first place, just to save my life. I don't think that's fair at all. It's not right. There's nothing but wrong here. It's injustice, not justice. You can't be a constitutional person and a statutory person at the same time. Either you're one or the other. And Wi-Fi wasn't working properly on my computer. I couldn't draw up my own paperwork. I've been in nothing but severe pain. I've been able to move around and do much of anything for myself. The only person the only one I've ever taken an oath to is God Almighty himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize. For me to sit there and agree to anything more than that would be me sitting there violating the laws of my God.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. As indicated, with respect to these sovereign citizen or whatever the other arguments you're making are, we've dealt with the jurisdiction issue in the past. I've ruled on that on at least one occasion, probably multiple occasions, and that ruling is not going to change. You will have appellate rights if you want to pursue those. You're welcome to do that, but you have pled guilty in this case. I think under normal circumstances that would be an adequate recommendation. With he's gone.
Oh, is Robert Matson there, please? Okay, who am I speaking with? Okay. All right, thank you. This is Mike Stevenson, probation. Okay, he had sentencing this morning. He just left the sentence. Judge, I just spoke with a female at the number that he gave me, and she claims that he is at a heart doctor appointment at this time. That's what she claims.
Everyone back with us now. Mr. Mattson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood, please. All right, I'm going to ask you to remove your hood also, Mr. Mattson. Thank you. Mr. Mattson pled guilty to one count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than 25 grams, pursuant to a plea agreement which dismissed one count of possession of cocaine, heroin, or another narcotic, dismissed one count of driving the license suspended, and one count of alcohol open container. So the agreement was to one count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Mattson's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has 2 2015 cases and a 2002 and a 2001. And so the recommendation in this case from the probation officer is for a period of 1 year of probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use. And I think that those provisions of terms of probation are appropriate given Mr. Mattson's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Mattson some help for his substance abuse problems. The concern I have in this case is that is whether or not Mr. Mattson is going to be willing to comply with the terms of his probation. He has, in numerous court hearings in this case, made a number of what he believes are constitutional and jurisdictional arguments that have absolutely no legal merit whatsoever. And he continued to challenge the court's jurisdiction here this morning. I understand that that may be an honest belief that Mr. Mattson has, and I don't know where it comes from, but I will say Mr. Mattson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that that raises with me is that Mr. Mattson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Mattson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him deal with that. So ultimately, Mr. Mattson, I'm going to give you a chance at probation. I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must pay the cost of your substance abuse testing. You must not be in possession, you must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician. And you must not be with anyone that you know to possess those items. You must complete an outpatient or residential substance abuse treatment when you are referred by the field agent. You must complete a substance abuse assessment when you are referred by the field agent. You must pay a $30 per month supervision fee, so long as there's no electronic monitoring. If electronic monitoring becomes necessary, that fee increases to $60 per month. You must also pay court costs of $750, an attorney fee of $450, a crime victims' rights fee of $130, and $68 state costs. And that, Mr. Mattson?
Yes, I do. Hey, Judge, I just had a couple questions, if I may, from you concerning what you just said.
All right. What's your question?
Well, if there's a crime victims fee, I'd like to know where the victim is, and also, Your Honor, you said something about the jurisdiction. If there's no problem with the jurisdiction, I mean, how come you couldn't tell me exactly which jurisdiction you're operating under? Because I would have to object to what you said. I mean, it don't make no sense to me, Your Honor.
I told you that before, Mr. Mattson. I'll tell you again. I'm operating under the jurisdiction of the Michigan Constitution that sets forth the fact that the state has various circuit courts. I'm the judge of one of those circuit courts, that one being where you are alleged to have committed this crime and where you pled guilty to this crime. As far as the crime victims' rights fee, that is assessed in every case where there is a guilty plea or verdict. That is done pursuant to statute that was enacted by the Michigan legislature, and it is required to be imposed here. So that is why I did it.
I'm not threatening you. Say one more word and that's 30 days. 30 days.